All it says is that civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of the Clerk of Parliament while he is on his way to attending at or returning from any proceedings of Parliament. In my respectful view, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesdays to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respectful view, I, the Attorney General, can, or any citizen of the land, having invoked the decision of the Supreme Court, can serve the process on a member of Parliament, the Speaker of Parliament, or a clerk to Parliament, except when he's on his way to Parliament or returning from Parliament. That's what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that Parliament of Ghana,
I know I have a right to reply, but it's done over 25 minutes. Yeah. Let me, we've been checking.
Attorney General, you have 1 minute left.
But I know I have a right to reply, especially that he got up only on points of law. So but he's exceeding.
Please sit down.
Yes. Yes, the point of law I made it because the application.
Please don't waste your 1 minute.
But I'm afraid. But the point I'm making is that the Supreme Court's judicial review powers, pursuant to Articles 2 Clause 1 and 130 Clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the President himself is even subject to Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high command under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court, in to form an Attorney General and further fortified by J.H. Mensah and Attorney General, reported in 1996 Supreme Court of Ghana Law Report, stated clearly that in Ghana, there's even no such thing as a political question. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, Counsel for Fair Defense.
Mr. Sorry, can we hear you on your objection?
My objection my Lord, the extreme right of the President arises from some of the...
My Lord, on the extreme what?
Right to my Lady the Chief Justice, to him being impaneled in this matter, arises from the fact that at a point in time, he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again...
No, I think you said enough.
From the
I think you
proceedings...
Said, no, I think you said enough. Kindly resume your seat.
Very well, my lady.
Let's go. Okay, don't.
This is like this case of this communication between
registry.
My Lord, with respect.
you gave your privilege of please stand. You gave your privilege of addressing the court to your junior, so we will not hear you, not on these matters.
My Lord,
we will not hear you.
I apologize. I was sitting in Parliament.
We will not.
Your Lordship, respectfully, we beg to move in terms of a motion paper, the supporting affidavit, and the exhibits attached. Your Lordship, we rely entirely on a statement of case filed on the 17th of May 2024.
Yes, a few points.
Yes, a few points, Your Lordship.
Okay, yes, go.
Your Lordship, respectfully, this review application is brought on the strength of, where we are stating clearly that the exceptional circumstances which has led to a miscarriage of justice, which warrants the review. Yes. Your Lordship, the nature of a decision refused or neglected to pronounce and determine a specific grounds of appeal, grounds III, and the failure to pronounce on that particular grounds, which in our view was material of the appeal, constitutes exceptional circumstances. Your Lordship, the authority, we take guidance and we place reliance on the authority of this Honorable Court of Tamaklo versus the Republic. Your Lordship, 2011 1 Supreme Court Ghana Law Report at page 29 was a product of a very serious inadequate consideration of the case presented. That is
what you said. Yeah. You rely entirely on your statement of case.
Yeah.
And this is what you are saying is very well articulated in your statement of case.
Yes, my Lord.
So why are you rehashing your statement of case?
Respectfully, Your Lordship, no. I'm laying the foundation to tease out a very important point before this court.
Tease away.
Yes, my Lord. Your Lordship, the point is that the specific ground of appeal which is in contention Chief Justice, I apologize just a second. Your Lordship, the specific ground in contention is this, that the Court of Appeal erred in holding that the second defendant was dogs and was not owner or keeper of the dogs. Your Lordship, respectfully, if you go through the entirety of the judgment of this court, through the lines and the pages and the paragraphs, nowhere that this Honorable Court pronounced on this particular ground. This particular ground was formulated to bring out two critical issues, which seem to have been glossed over by the trial court and the Court of Appeal. court state the dogs that caused that on the premises as a commercial premises because in the issue, when it comes to the issue of negligence, specifically this case where a dog bites someone, question is who is the owner, keeper, or who has control? Because the duty bearer
has ownership and control over the premises.
Your Lordship,
From where the
yes, Your Lordship, the case is settled. Even the case where the Honorable Court relied upon is settled.
also the court actually made reference with and relied upon something.
Relied on a case that did not of answering the specific question. This court, placing reliance on the case in question, did not address that particular question.
Counsel. You see, review is conceptually different from an appeal.
Yes.
And it even came to a conclusion which is wrong.
For the original case.
You do not, our jurisdiction to review is not proper to invoke it. It's not proper to invoke our jurisdiction to review. But from what you just said, it looks like we adverted our minds to it, but the conclusion that we came to, you were not happy with it.
Respectfully, Your Lordship, not at all. Because that particular case stated emphatically, and if Your Lordships would permit me, I would read, in response, direct response to Your Lordship's question, whether a person who allows a dog on his premises to cause injury is liable in negligence. And the answer is an emphatic no. Your Lordship, in the case of North versus London Council, 1930, that the knowledge of the schoolkeeper that the dogs was accustomed to attack mankind was not acquired by him as a servant of the defendant, and the plaintiff showed no cause of action against the defendant. I think, so per Lord Wright, he says, I think both.
What you are referring to is clearly stated in your statement of case.
My Lord, it's not. It was stated in the statement. My Lordship, it's because of a question that has been posed. And because there was you have to be careful not to relitigate the matter. But the question is specific.
Statement of case. But you made reference to North versus London County Council 1994.
Yes.
On, I don't know, you didn't page your you didn't page your statement of case, but it is there. What you are reading, I just want you, because you said you have read, we'll read it. So if you are going to tell us you have anything to add, that it is something that should be substantially different from what you tell if you continue to do that.
Respectfully, Your Lordship, the question that my Lord raised is what is at the heart of this review company. And we're not keeper or owner. The law is established that it is only the keeper or owner who is liable in negligence. First, who owes a duty and also is liable in negligence.
How about the owner of the premises?
My Lord, that's what we are saying that yes, my Lord.
You have referred to North versus London County Council in your statement of case.
My Lord, then that particular reference was in respect of a particular ground which had to do with leasing. My Lord, this is the point that it says in Smith versus Great Eastern Railway Company.
So hold on.
Yes.
Let me read yours out of your statement
Yes.
of case to you, which is not paid. My Lord, grounds 3 became relevant for consideration, having regard to the fact that the first appellate court rested its decision of imposing liability on the applicant on the strength of the authority of North versus London County Council. Yes, is a different point you seek to make now.
Yes, Your Lordship, in placing reliance on the North case, what this court was referring to was that the court had come second defendant were both owners of the dog. It is that which unsurprisingly led this court to the error it made in respect of who bears the legal duty. Your Lordship, the ground for review.
It's not, bear in mind that it's not an appeal.
Yes, my Lord. This is the first time we are raising that question that there must be a distinction between the first defendant and the second defendant. No, for the review. The lordship for the review court. In the ordinary bench, the keeper and the controller of the dog, it was the defendant's dog, and therefore absolutely no duty. And my lordship.
So are you saying, just for the sake of argument, that who had the duty, the first defendant, not the second defendant?
Absolutely. So we have not. Yes, there's a director of the
first is a director of the second defendant.
Correct.
But so the liability you are saying is for the first defendant, not the second defendant. That's what you are saying.
Absolutely.
A case. So we are live at the Supreme Court of Ghana, where is Alexander Afeyo-Markin, who is the leader of the NPP caucus in Parliament, versus, but counsel for Alexander Afeyo-Markin was led by Joe Gatti, who is MP for Ketan, and Samuel Atachia, MP for, and Adam Strai. And then also the Attorney General himself, Godfrey Yeboah-Dame, assisted by his colleague Alfred Tuah-Yeboah, and a host of preliminary objection was raised by the Attorney General Godfrey Yeboah-Dame regarding the process the Speaker and lawyers for the Speaker, in fact, had served the Supreme Court following their receipt of court's decision for the Parliament vacant based on their intention to file as independent members of Parliament. And on the very topical in the last couple of weeks, NDC caucus, Dr. Kesa Aguna West, Cynthia Mamle Morrison, member for, and then two others of the NPP to Parliament, but also come on the ticket of the NDC. And the second deputy speaker, Andrew Samuel-Kwesiama, who came as an independent candidate, had also switched camp. Leader of the NDC caucus, Dr. Atuforsen, prayed the Speaker to declare their seats vacant. Those seats, the Speaker, after 2 days of consideration, declared vacant. After this, the leader of the NPP caucus, Alexander Afeyo-Markin, MP for Efutu, also execution of the matter in order for the court to also have time to determine the constitutionality of declaring such seats vacant in an upcoming election, because according to him, the constitution was not so clear on that matter. Now, when the case was heard at the Supreme Court last 2 weeks Friday, the court in their capacity as sitting MPs and not have their seats. Now, after this, the courts had to serve the Speaker notice of the ruling that they had done to stay execution. Mr. Speaker and through his lawyers, Thaddeus Sori and co, also wrote back, whereas that in 7 members of Parliament, or that the Thaddeus Sori, the service that was done by the court was not done on a Monday, and it was in contravention of the court's own ruling. And so today, the court is sitting on the matter, but just as the substantive matter was to be raised, the Attorney General, Godfrey Yeboah-Dame, rose an objection for the Speaker for they found it rather disingenuous for the court in ruling was, and so the Chief Justice, who is leading the panel, the 5-member panel of the bar, including Justice Jolene Kulendi, makes such an assertion. And so that is what has happened and transpired in court, with Mr. Sori making his submission, and the Chief Justice is going in conclave and has gone in conclave a ruling on this preliminary objection that has been raised. We'll have my colleague Sarah Ofori joining me now, so that we look at what has happened so far. So Sarah, welcome.
Thank you.
So we now have the 5-member panel of the Supreme Court going in conclave.
I believe this is a test of democracy. Two independent bodies, I wouldn't say at loggerheads, but in disagreement. It has been said, or the law makes it clear, that the judiciary is an independent body. So is the legislature. So as to the legislative body makes laws, and the judiciary interprets the law. But we also know that before a law is made, usually the Attorney General will make inputs before it's laid. In this case, the Constitution is what is being tested. Parliament has its own standing orders and has made a ruling, and the judiciary to find out how best right. The court proceedings is ongoing. The lawyer for the Speaker of Parliament, Mr. Alban Bagman, is trying to defend the judiciary body. So has no right, for want of a better expression, to overturn its ruling. So, I mean, this is a test of our democracy, and we live to see